Discussed with members assembled in the room today if they have a difficulty with me removing my mask. They've indicated that they're sufficiently comfortable about the distance between us. My challenge is that the whole time while I have the mask on. So with your leave, I request that I remove it when I'm questioning Mr. Mothibe and when I remain at the podium.
No, you may take it off. As I understand it, when we speak, we may take it off.
Thank you.
That's in order.
Thank you, Chair.
Thank you. And to the extent that the witness also might not be clearly audible when he speaks, he can take it off as well. Yeah, okay.
Thank you, Chair. Chair, I propose this morning before we commence to swear in the witness, just to orientate ourselves as to where we are.
Yes.
In the aviation evidence in particular, because we've had quite a number of months break.
Yes, no, I do need to be reminded where everything fits in.
Certainly.
Yes.
So if I may proceed to that.
Yes.
Chair, in February this year, we had a session of aviation and related evidence. And it was towards the end of that session that we began looking at the role of auditors in the SAA group of companies. And you'll recall that we heard evidence from Mr. Polani Sokombela, who was a business executive in the Office of the Auditor General, and he was the person who'd led the audit at SAA and its group of companies for the 2017 financial year. Chair, you'll recall that before the Auditor General took over SAA's audit in 2017, the group had been audited by joint auditors comprising PwC and Nkonki Incorporated for the previous 5 years. In February, we'd intended to move straight from Mr. Sokombela's evidence to the evidence that we're in fact going to receive today from Mr. Mothibe. Mr. Mothibe was the audit partner from PwC assigned to the SAA audits for the years 2014 to 2016, but we unfortunately ran out of time during the February evidence session, and so we've returned today to present Mr. Mothibe's evidence. Chair, in the public sector, auditors have a particular role to play. In addition to the usual responsibilities that they have when they audit private companies, they are required when they audit public SOEs to assess, amongst other things, the levels of that state-owned enterprise's compliance with legislation, including and importantly for our purposes, the Public Finance Management Act, which we colloquially call the PFMA, and which really sets the test for regular procurement in a state-owned enterprise context. Chair, we propose to explore in Mr. Mothibe's evidence a number of factors related to auditors in the public sector. And the question will be whether they properly discharge those obligations which are additional to the ones that they bear when they audit private companies. Chair, we submit that this inquiry is relevant to the Commission's mandate because one of the questions that you've emphasized repeatedly over the years now that this Commission has sat is the how question. If this Commission concludes that state capture, corruption or fraud did take place in the public sector, then it is supremely important for this country and for its future for us to understand how it occurred and indeed why it went unchecked. Chair, auditors are a watchdog institution. I gave you the reference last time to the case law that establishes that. And given their role and function, it's therefore fair to ask, if all this corruption and looting was potentially taking place in our public institutions in the past, how was it that auditors did not pick it up? In the context of SAA, that question becomes particularly pressing because after PwC and Nkonki had completed their 5 years of auditing for the group, the Auditor General stepped in to audit SAA for the 2017 financial year and found its finances in a state that can only be described as shambolic. So today we are going to focus on the following, with your leave, Chair, with Mr. Mothibe. The first aspect we'll probe is the fact that, except for the first year of PwC and Nkonki's appointment, all 4 subsequent years they were appointed without any procurement process being followed. And this was against the advice of the Bid Adjudication Committee of SAA at the time and a legal opinion that was later procured. Their own appointment, therefore, constituted irregular expenditure for 4 solid years, and yet it was never disclosed as such in the financial statements. We'll then explore why it was that PwC and Nkonki both had joint business relationships and made payments to an auditing firm called Kwinana and Associates during their audit work for SAA. Now, Kwinana and Associates was the auditing firm of Ms. Yake Kwinana, who was both a non-executive member of the board of SAA for the period that these 2 firms were auditing the doing audit work at SAA, but she was also the chair of the Audit and Risk Committee at SAA, the very committee which year on year would approve the audit fees to be paid to auditors. We will then, in the third place, explore why not one of the significant transactions that have been dealt with extensively in the evidence before this commission, and which there are indicators may have been the subject matter of fraud and corruption, and possibly state capture within SAA, and were products of the decisions of the board of SAA, and in one occasion SAA Technical, was not identified by these auditors as reportable irregularities. And we'll spend some time just traversing with Mr. Mothibe what reportable irregularities are. We had a bit of evidence on that from Mr. Sokombela, but not much. So I plan to pursue that with Mr. Mothibe today. That obligation on auditors to report reportable irregularities is an important one, a serious one, and their failure to do so is in fact a crime under the relevant legislation. We submit that in the end, the Commission will need to determine whether any state capture, corruption, or fraud that it finds to have taken place in the public sector was in any way facilitated by the auditors of state-owned enterprises. If it was, then the next question will be whether that facilitation was due to mere negligence, auditors simply not doing their jobs as they were supposed to, or something more sinister than that. Chair, we submit that even if it is only the former, even if state capture, corruption, and fraud was not picked up by auditors of state-owned enterprises because of nothing more than their mere negligence, it is still important to expose that, because public funds were used to pay them for inadequate and substandard work. And the public deserves better than that from a watchdog institution. It may be, Chair, once these matters have been traversed not only in SAA but other SOEs, you may consider recommendations like the Auditor General should be better capacitated and should be running all the audits at state-owned enterprises with the level of dedication and commitment that we saw from Mr. Sokombela and his team as he dealt with in evidence before this Commission over 2 days. Or it might be that you make recommendations that the annual review that the Auditor General is required to do under the legislation at the moment to approve external firms coming into SOEs should be stricter. There should be additional criteria. Those are the sorts of recommendations it may well be that this Commission wants to consider in due course. And so, Chair, it's with that background in place and just a reorientation of where we are, that without further ado, I have 2 procedural matters just to mention, and then I would beg your leave to swear in the witness.
Thank you. Please administer the oath of affirmation. All persons who are in the room must take responsibility to make sure that there is proper social distancing between themselves and the next person. I don't think that if you are sitting in the one row and there's somebody sitting immediately behind you in the next row, that that's 1.5 meters or 2 meters. So do consider, there may be constraints that I don't know, but I just want to make sure everybody remembers that we must still try and, it may be that for TV or whatever, there are other constraints. I leave it to you to think about that, but there's enough room to make sure that there is proper social distancing. Okay, all right. Thank you.
Thank you, Chair. Please state your full names for the record.
Pule Mothibe.
Do you have any objection to taking the prescribed oath?
No objections.
Do you consider the oath to be binding on your conscience?
Yes, I do.
Do you swear that the evidence you'll give will be the truth, the whole truth, and nothing else but the truth? If so, please raise your right hand and say, "So help me God."
So help me God.
Thank you. You may be seated.
Thank you, Chair. Just a few procedural matters before I begin with the questioning. Mr. Mothibe is represented by a legal team. They did previously introduce themselves to you on the last occasion, but I wonder if I could seek your leave for them simply to place themselves on record.
Yes,
Chair, it might be convenient for Mr. Chappell to do so as he's seated at the moment, so we
That's
don't
fine.
have to move the
Yes,
podium and
that's fine.
sanitize it.
Let's do that. Good morning. Good morning. You can just put on, yeah, yes.
My name is Tony Chappell from the law firm Norton Rose Fulbright, and I have with me two of my colleagues, Ms. Ndluli and Ms. Thompson.
Thank you. Thank you.
Thank you, Chair. Then on two final procedural matters, insofar as Rule 33 notices for Mr. Mothibe's evidence is concerned, that was done way back in February. There was one notice sent to Ms. Yake Kwinana. We received simply a 2 or 3 paragraph email in response from her. Chair, you've previously indicated in these proceedings that you require a proper and formal response to any affidavit that is sent to implicated persons. Ms. Kwinana does not purport in that email response to seek leave to cross-examine or any such thing. She simply puts up a few points in that email. I don't propose to deal with that with Mr. Mothibe today. It's in any event the intention of the Commission, and we have engaged Ms. Kwinana about this, to have her come and give evidence in due course, and so any matters arising there will be dealt with in that evidence.
No, that's fine.
And then the final procedural matter, Chair, is I understand that the Commission has received an affidavit from Mr. Simon Mantell, whose company Mantelli's Biscuits was awarded an SAA tender in 2014, which shortly after the award was summarily withdrawn. I had intended to question Mr. Mothibe on possible relevant matters arising from Mr. Mantell's affidavit, but I've been informed that his affidavit is forming part of a different process within the Commission. I have not considered it as a result, and I will not be traversing matters with Mr. Mothibe today in relation to Mr. Mantell's affidavit.
I wonder what process it is part of, because the last I knew was that one of the things you were considering is seeing whether the information that Mr. Mantell gives in his affidavit could be used to question Mr. Mothibe.
Indeed.
So I'm not aware what that process is, and nobody has talked to me about that process. So I'm concerned about that.
Chair,
because you had considered it as a possibility.
I had indeed.
Maybe during the tea break, you could talk to me.
Certainly, Chair.
I'm concerned about that.
Indeed.
You know, because also I think correspondence that may have gone to Mr. Mantel may have alerted him that this was a possibility.
Yes.
And he might not have been told anything.
Yes.
And he might be concerned to say, this I was told was a possibility, but now it's not happening and nobody has bothered to tell me what's going on.
Chair, can I say in response, I share your concerns. I do. It had always been my intention, but late last week I was given this information. But let me, if I may, over the tea break, raise it further with you. Thank you.
Okay, thank you.
Chair, then to move to Mr. Mothibe, finally. Apologies for the delay, Mr. Mothibe. Mr. Mothibe's evidence, Chair, is Exhibit DD19, and I request that we enter it into the record as such. It comprises initially a first statement and a series of annexures and then additional documents, but since the evidence in February of Mr. Sokombela, Mr. Mothibe then supplied a few weeks ago a supplementary statement, and so we've also just inserted that in the appropriate place in the bundle that had previously been prepared, and it spans more than a single file, so I beg your leave to enter it as Exhibit 19A and B.
There is the Liver Arch file marked DD, Exhibit DD 19A, and then there is one marked Exhibit DD 19B.
Correct.
I guess that the first statement is the one in A,
Correct, Chair.
and then the supplementary would be whereabouts?
It's
Would
just
it be-
after it. It commences at page 30.1 because we slotted it in so that it could, his two statements together would appear at the commencement of the file. So you'll see his first statement runs from page 1 of DD 19A to page 30 with its annexures. And then
I'm sorry. Did you say 15 something or 50?
no, apologies, Chair, 3030.
53.
No, 3030.
330. Okay.
So 30, and then the second statement commences at 30.1, 30.1.
Okay, I found it.
Excellent.
And what is in 19B?
It's the further
Continuation of
additional
annexures.
documents.
Yeah. Okay, all right. In the meantime, since the last time, I'm not sure, we have been emphasizing that the file is not the exhibit, but the statement is the exhibit. And for convenience, what has been done in regard to, in some of the matters, is to call the file bundle something.
Right.
But the statements is exhibit whatever, and it's annexures.
Okay.
So we'll when we talk about the exhibit, it will be a reference to the affidavit and its annexures.
Yes.
And yeah, okay. The affidavit of Mr. Pule Mothibe, dated or deposed to, or is it in the form of a statement?
It's in the form of a statement. It
Yeah.
was a request that it be provided as a statement so it could be confirmed under oath today.
Yeah, okay,
But you'll
no,
see
that's
it's
fine.
signed on page 14 on the
Yes.
22nd of January,
Yes.
2020.
The statement of Mr. Pule Mothibe, don't think it's got a date, or it does have a date, dated 22 January 2020, is admitted together with its annexures as Exhibit DD 19A. Now, the other statement, or is it an affidavit, that one?
No, that one is also a statement.
I just saw on page 31 saying affidavit, so.
Yes, sorry.
Oh, that's somebody else. No, I'm sorry. I think that is somebody else.
That's another person's affidavit.
another
That's from Ms.
person, yeah.
Masasa. We'll come to that.
Supplementary statement. Now, from what you said earlier on, I think you intend that we take this as a separate exhibit rather than an annexure through the other statement, or?
Chair, my suggestion is that we keep it in Exhibit 19A because it's been separately identified by its pagination numbers, 30.1 to 30.6.
Yes.
So I'd like to suggest we keep it in Exhibit 19A because that's how the referencing for my questioning today has been prepared.
Yes. It might not be mentioned as an annexure because they're separate statements.
They are separate, yes. So it might be his supplementary statement which appears from page 30.1 to 30.6.
Yeah. Now, I see there is an affidavit later on. That's not an annexure to anything?
No, these are, once you finish this.
It will be an annexure to the first statement?
No, it's actually now the additional documents. So once you complete the second statement, or what we're calling the supplementary statement, the remainder of A continuing into B is all the additional documents that have been produced and discovered in the course of the Commission's investigations, but they're pertinent to Mr. Mothibe's evidence. They do include affidavits of others, and when I was going to come to them, I'd explain the circumstances for their inclusion. None of them are contentious, but from page 31 then in DD 19A, it's a series
take that off. Whatever they plug, they must take it off. So cut.
we were at a point where I was trying to think whether what we should do with documents that are not annexures
Yes.
to the statement, because normally I would say the statement is admitted as exhibit so and so
Yes.
together with its annexures, then it's easy. But if it's documents that are not annexures,
Yes.
they might need to be separately identified or admitted as exhibits in their own right.
Yes, yes, yes.
So, which we can do, because we can say Mr. Mothibe's statement is Exhibit DD 19A, and then
Yes.
we say B, C, D,
Yes.
up to wherever.
Yes.
Would it be easier to do that immediately, or
I think
as you refer
as
to
we
each
go.
document? Yeah.
What I'm going to ask, Chair, is that I just be assisted. There's a new member of the legal team, Ms. Amy Armstrong, who's assisting me today.
Yes.
She'll be presenting evidence tomorrow.
Yeah.
If she can just keep a running list for me of where we are in the alphabet.
Yes, yes. No,
Then
no,
as
that's
and
fine,
when
yes.
I refer to a new document,
Yes, it
we
can
will
be,
enter it
yes, yeah.
appropriately. Yes.
No, that's fine. So, as I have already indicated, the Mr. Mothibe's statement dated 22 January 2020 is admitted as Exhibit DD 19A, together with its annexures. I think it's got a few annexures. Is that
Correct,
right?
correct.
And then I think what comes after that, I think the annex shall probably go up to just before the supplementary statement.
That's exactly right, yes.
Maybe we may as well just deal with the supplementary statement
Yes.
as well.
That's not a problem.
So, Mr. Mothibe's supplementary statement, it's undated supplementary statement, undated supplementary statement. It reads, supplementary statement by Mr. Pule Joseph Mothibe concerning joint audit of South African Airways Group's SOC Ltd SAA will be admitted as Exhibit DD 19B. It appears on page 30.1. And then others we will
Indeed.
deal with as we go along.
Certainly.
Okay. All right.
Thank you, Chair. I'm indebted.
And then what will be necessary to do is that on the spine of the file, it should be
All the-
reflected what exhibits
Indeed.
are inside here.
Certainly.
Okay. All right.
Thank you,
Thank
Chair.
you. Yes.
Mr. Mothibe, then to commence. If you can just put your microphone on. I understand there's no difficulty with you leaving it on, and it's just easier, then you don't have to worry about turning it on and off in the questioning. Mr. Mothibe, if we start with your first statement, you'll see it begins at page 2 and it runs to page 14 of Exhibit DD 19A. Can you confirm that that's your signature on page 14?
Did you say it starts from page 2?
Page 1. If I said 2, that was an error. It's certainly from page 1 to
Yeah.
page 14. Thank you, Chair.
Chair, that is my signature.
And can you confirm that the contents of the statement are true and correct?
The statements in the comments in the statements are true and fair, Chair.
And are there any corrections you'd like to make to the statement?
There are no corrections.
Thank you. Mr. Mothibe, can I just suggest for your convenience that you move, yes, I think it'll just be a little bit easier for you. And it also just helps to amplify your voice.
Thank you.
And then there is your supplementary statement, which we've admitted as Exhibit DD 19B, and that runs from pagination 30.1 to 30.6. Do you see that?
Yes, I do, Chair.
And can you,
I'm sorry, Ms. Hofmeyer. I'm concerned that for some reason, I don't know whether it's the mic, whenever you mention the page number of that statement, I always hear 50.
I don't know, maybe I must try and
So,
articulate a little bit more clearly.
I'm wondering whether the transcribers are hearing
Yes, let me-
30 or 50.
50. Let
Otherwise
me
they
be
write the wrong thing.
Let me be clear, it's 30 with a 30. So it's 30.1 to 30.6. Do you have that, Mr. Mothibe?
I've got the statement, Chair.
This was not signed. That is not a problem. I understand the challenges under lockdown when you were producing this. Can you simply confirm for us under oath today that its contents are true and correct?
The contents are true and correct, Chair.
Yes, thank you, Mr. Mothibe. I'm concerned your voice is quite soft. I don't know whether it's because of the mountain of files next to you, or do you want to try and raise it?
I will raise my voice, Chair.
That's much better, yes.
Thank you, Chair.
Thank you.
And just to check, there are no corrections that you'd like to make to that statement, are there, Mr. Mothibe?
There are no corrections, Chair.
Thank you. Mr. Mothibe, I'd just like to start with some background, if we may. You indicate in your first statement, that's in Exhibit 19, DD 19A at page 1, that you are a registered auditor. Is that correct?
That is correct, Chair.
Can you tell the Chair when you completed your articles?
Chair, I completed my articles at the end of December 1995.
And what qualifications do you hold?
I've got a Bachelor of Commerce degree and a higher diploma in accounting.
And when did you become a partner at PwC?
Chair, I was admitted to partnership on the 1st of July 2003.
And when did you take over as audit partner for the SAA group of companies?
I took over as partner on South African Airways group of companies for the 31 March 2014 financial year.
And did you remain in that position until the 31 March 2016 audits were completed?
That is correct, Chair.
And how many years did PwC in total audit the SAA group with its audit partner, Nkonki Inc.?
Chair, it was for a period of 5 years.
Thank you. I'd then like to move to the topic of the requirements for auditing state-owned enterprises and talk a bit about auditing procedures. Could you tell us who designs the auditing procedures for an audit, Mr. Mothibe?
Chair, the audit procedures would be designed by the audit team. That is the audit firms that are executing the assignment.
Now, in the course of preparing for your evidence, Mr. Mothibe, you provided to the Commission some of the working papers for those audits that you still retained as PwC. And we took a look at those and tried to decipher from them what sorts of procedures you and your team had devised for the audits that you conducted at SAA. And so I'd like to check with you if we are correct in understanding that one of the things that you would do in your procedures was to study the minutes of meetings that took place within SAA. Is that correct?
Chair, one of the procedures that we do carry out is the review of minutes of boards, audit committees, and other relevant committees.
Thank you. So you've mentioned the board, so you would consider board minutes, would you?
Chair, that is correct.
And would you consider the minutes of the Bid Adjudication Committee as one of the committees?
Chair, that will be considered by the team that is carrying out work in a specific audit area. It may be one of the areas that they look at, but there are other areas, Minister, that they'll also consider.
Yes, I don't have a difficulty with there being other ones as well. I just want to get clarity on whether it would be part of the audit procedure to consider bid adjudication committee minutes.
Chair, to the extent that it is relevant, yes.
When would it be relevant?
Chair, if one is looking at a contract and they may be following procedures relating to approvals.
Mr. Sokombela, in his evidence on the 21st of February 2020 this year, Chair, I don't suggest we go there. I'm just for the record going to give you the reference. It's in the transcript at page 103, lines 8 to 10. He said that his team certainly considered bid adjudication committee minutes. Would you agree with him that it's good audit procedure to look at those minutes amongst others?
Chair, I don't think it would be necessarily appropriate to comment on the work performed by Mr. Sokombela. I'm comfortable to comment on audit matters as far as it relates to work that I had performed. Otherwise, I'll be speculating, Chair.
Let me ask you, Mr. Mothibe, then, do you regard it as a good audit procedure to consider the minutes of the bid adjudication committee at a state-owned enterprise?
Chair, in as far as it would be relevant to the area being tested, it would be a good procedure.
And if you're testing supply chain management and its compliance, should you be looking at bid adjudication committee minutes?
Chair, it would make sense to look at bid adjudication minutes.
Mr. Mothibe, would you also, as your audit procedures, be reviewing media reporting about the entity that you're reviewing and auditing?
Chair, it is not a requirement of the standards, auditing standards, to look at media reports when one is performing an audit.
Did you say it is not a requirement?
Chair, yes, it is not a requirement, Chair.
Did you look at media reports in your own audit procedures?
Chair, we did look at media reports to the extent that we could find what we could find.
Yes, Mr. Mothibe, you actually looked at them quite extensively, as I understand it. And for that purpose, I'd like us to go to a document that, Chair, you'll currently find, and Mr. Mothibe, you'll currently find in the file that on the spine is numbered DD19B. Chair, I'm just using that reference so that you can find it. I'm mindful of your request that we now enter them as separate exhibits. But if you go into DD19B at page 443, do you have that, Mr. Mothibe?
Chair, I do have the...
Now, we're going to enter this as the next exhibit, but I'd like you just to explain to us what this document is.
Chair...
1 second.
Apologies, Chair.
Please don't forget the question. I'm just wondering if we are going to enter it as the next exhibit.
Yes.
Normally, one would prefer to have that sequence where
Yes. You see,
under A, it's sequential until we
Yes.
go to B, to the next lever arch file. I'm just thinking, but of course, what you can do is that we could go to various exhibits in both files, even though we end up with, for example, D being in the first lever arch
Yes.
file and E being
Yes.
next.
Yes.
But later on, you could put them in one lever arch file, the one set,
Yes, yes.
to be sequential, and then create another one that is sequential. That could be done.
We could certainly, Chair, the only
Yeah, but there
challenge...
may be another way of doing it.
For today's purposes, my difficulty is the only way that I can direct all of us to the page I'm interested in is by its current pagination.
Yes, yes.
So, and that was devised assuming that we would use the method that we'd been using previously, which
Yes.
was the DD19A for the
Yes.
first file, DD19B for the second
Yes.
file, and
Yes.
sequential pagination
Yes.
throughout.
Well, I'm wondering whether we shouldn't be creative and give these two lever files bundle numbers, even if the bundle numbers are not necessarily sequential
Yes.
to whatever other bundles
Yes.
have been given,
Yes.
so that we can say exhibit so and so isn't bundle
Yes.
that, and
Yes.
we say bundle so runs from page whatever to page whatever. Do you think that might?
I do think so. I mean, the
Yes.
simplest way for today's purposes
Yeah.
might be to, all that you've entered so far is DD19A and
Yeah.
DD19B. Those are the
Yes.
two statements,
Yes.
right? My suggestion is that we then say that DD19C will be the documents running from, and then I'll give you the pagination
Yes,
now.
yes.
It will be, I think I can remember, page 31 to page 250.
Yes, yeah.
And then DD19D will
Yeah.
be from page 251 to page 6, I just have to get it here, 624.
Yes,
Because
yes.
then we're going to be set for the day.
Yes,
Then I
yes.
won't have difficulty, then I can take you to the
Yes.
number.
Yes.
Will that be convenient,
Yeah, that
Chair?
would be fine. Let's do it that way.
Super.
Do you want to?
I'll just repeat it if
Yeah.
I may. So we've entered DD19A and DD19B into the record. We would then be entering DD19C into the record, and that will run from paginated page number 31, that's 31, to paginated page 250, 250.
I'm sorry. Did you say 19C or D?
C.
C, yes.
Yes.
C, that is at page 31
Yes, until page 250.
until page 2. Is that up to the end?
Correct, yes.
Or end of the second lever arch file? Oh, no,
First
no.
lever arch file.
Or end of the first lever arch file? Yes, okay. So that will be, all of those documents
Yes.
will be admitted as Exhibit 19C, and then they will be differentiated by a reference to the page numbers.
Exactly, Chair.
Yes,
That's going to be very convenient for
Yes,
us.
yes,
And then
yes,
just to be
yes.
clear for the record, what will then be entered as Exhibit DD19D for dog will be pages, you'll find that in the second file, Chair, and that runs from page 251 to page 624.
It's 2512.
To page 624, 624.
I think what we'll do is this could be done later on. We might have to identify each document and maybe use ABC or AA, BP,
Yes.
whatever. But for today's purposes, we will say that Exhibit DD19D starts from page 251 to 624,
Yes,
subject to later qualification and amendment.
certainly, with the separate identification
Yes,
of the document.
yes,
Thank you, Chair.
yes,
We've made a
yeah.
note of that.
Yes, yes, thank you.
So then just to take us back to where we were, Mr. Mothibe, we are in what has now been entered as Exhibit DD19D, and we were at page 443, and I was asking you to help us identify this document. What is this document?
Chair, as part of maintaining our understanding of the client, we use information that comes to our attention.
I'll
Whilst
ask you to raise your voice again.
apologies, Chair.
Yes.
Whilst it is not a requirement of the standards to go through the media to obtain such, Chair, to the extent that there are articles which have a bearing on our client and provide us information that helps us to obtain an understanding of our business and what is going in there, which helps us in confirming our risk-based audit approach. And we certainly do take account of those articles. To go out and it will not be possible to go out and search, because there is quite a universe of articles out there, Chair, and you will not be able to identify every single one of them. So to the extent that we identify articles that are relevant, we do look at those.
Ms. Mothibe, was it part of your audit procedure to look at media articles related to the SAA group?
Chair, as part of our audit procedures, we looked at those media articles that came to our attention.
Yes, you say at page 442, under the heading Purpose of EAG, in accordance with the risk-based audit approach, we stay up to date with media. Apologies, Chair.
My 442 is a
Sorry,
table.
443, Chair.
443.
443, apologies.
Okay, yes, okay.
I was reading from the words that appear under the heading just after the table at the top, the purpose of the EGA, but let's look at the table first. This relates to the engagement for the SAA group audit for 2015. Is that correct, Mr. Mothibe?
That is correct, Chair.
And so the period end date of that audit is the 31st of March 2015. Is that correct?
That is correct, Chair.
It says audit unit in the next line, SAA Group Audit 2015 HQ. What does HQ stand for?
That's head office.
Headquarters, maybe, I don't know. Is that
Yes,
it?
headquarters, head office. That is correct, Chair.
And it says EGA title. What does EGA stand for?
There is a engagement gathering evidence.
Right.
There is a Chair. There is a PwC acronym that we use, Chair.
So this is how you acquire audit evidence. Is that right?
Amongst others, Chair, this is one of the ways that we
Yes.
would acquire evidence.
Yes, the audit evidence that's going to inform the audit that you conduct, correct?
That sounds correct, Chair.
And then under the purpose, there is the following. I'll read it into the record. In accordance with...
I'm sorry, Ms. Hofmeyer. Did you say EGA represents one of the ways in which you acquire evidence?
Chair, EGA, it's an acronym we use in PwC, which relates to sort of, if I recall.
Maybe you can start by telling me what E stands for G and A, then that might help me. Or it's just or there is no particular full name for it or full.
Chair, if my memory serves me right, Chair, it should be evidence gathering activity, Chair. So
that helps. That helps. Yeah. Okay. So no, then I understand.
Yes, Chair. Thank you, Chair.
Okay.
And when you describe then later below the table on the page the purpose of your evidence gathering activity, you describe it as follows. In accordance with the risk-based audit approach, we stay up to date on media reports pertaining to SAA and to evaluate the effect thereof in the financial statements, identify risk, and therefore update our audit approach on a continual basis when necessary. Do you accept the accuracy of that statement about the purpose of your evidence gathering activities?
Chair, that is how the purpose reads, Chair.
Mr. Mothibe, you were present for the evidence of Mr. Sokombela, is that correct?
Chair, I was present for part of the evidence.
Have you considered the whole of his evidence before giving evidence today?
Chair, I've had a look at Mr. Sokombela's evidence. I've briefly had a look at that, but not probably in that kind of detail, Chair.
But were you aware then that he emphasized that looking at media reports would be an important part of and did form part of the approach that his team took to the audit in 2017?
Chair, as I indicated earlier, it is not a requirement of the standards for one to look at media reports. However, and as we have also done during our years under review, we did look at media reports that came to our attention and those that had an impact or provided information that could prove useful when we audited the client.
Are you aware that it's part of IRBA's guide on reportable irregularities that you should keep abreast of press reporting about the entity that you're auditing?
Chair, could I ask Ms. Hoffmer to repeat the question? I'm not too sure that I understand what...
Sure. Are you aware of IRBA's guide regarding reportable irregularities?
Chair, I am aware of IRBA's guide relating to reportable irregularities.
Do you seek to act in accordance with it when you audit companies?
Chair, we act according to the guide at all times when we audit our clients.
Are you aware that the guide indicates that auditors should be considering press articles about an entity when they are auditing it as one of the means by which you are assisted in identifying reportable irregularities?
Chair, I would have to remind myself of that, but certainly, Chair, we did consider media reports relating to South African News Group of companies when we carried out our engagement.
Thank you. Mr. Mothibe, in my introduction today, I indicated that when an auditor audits a state-owned enterprise, there are additional obligations on that auditor as compared with when the auditor simply audits a private company. Do you agree with that statement?
Chair, as I've indicated in my statement, Chair, can I refer Ms. Hofmeer to...
You may refer to your statement.
Oh, certainly. You'll find that in DD 19A, and it commences at page 1.
Thank you, Ms. Hofmeer. Chair, on page 1 of my initial statement, on DD 19 PJM 01. At the bottom of the page, Chair, the last paragraph, we confirm there the auditor's duty.
You can read that paragraph if you want to.
Thank you, Chair. The auditor's duty in a statutory audit is to provide an opinion concerning whether or not the annual financial statements fairly present the entity's financial position and the results of its operations and cash flow information in conformity with generally accepted accounting practice. So, Chair, that is our primary role as auditors. And we are also required to comment as to whether the report would confirm that the financial statements are prepared in accordance with the requirements of the Companies Act. When we audit state-owned enterprises, we do so on behalf of the Office of the Auditor General. And he has issued guidance which require us to also consider matters of compliance with laws and regulations, which, by the way, Chair, is a requirement of the auditing standards. So, Chair, much as there are additional guidelines from the Office of the AG, they are in fact covered by the ISAs when it comes to, because you are required to consider compliance with laws and regulations in terms of, I think it's ISA 230, Chair, I'll have to confirm the exact numbering. But Chair, the audit standards sufficiently cover that, Chair.
Thank you, Mr. Mothibe. I'm grateful for your clarification on that point. If I can direct you to paragraph 9 on page 2 of your statement, which for reference purposes is in Exhibit DD 19A, you'll see a paragraph 9 there. You sum up, I think in essence, what you've described now to the Chair. You say for all audits, the auditor is required to comply with international standards of auditing, known as the ISAs. That's what you were referring to a moment ago. Is that correct?
Chair, that is correct.
And then you go on, you say the ISAs require the auditor to consider relevant and applicable laws and regulations that may have a material impact on the financial statements as a whole. I take you to the point you made earlier, is that applies whatever company you're auditing. Is that correct?
Chair, that is correct. If I may give an example, Chair, when you auditing a bank, Chair, there are additional requirements in terms of the Banking Act. So you'll have to bring that into consideration. When, Chair, you are auditing an insurance company, there is legislation specific to insurance companies that you have to consider. So when you audit state-owned enterprises, it is then the PFMA that is brought into the picture. So in essence, Chair, an audit is an audit. There are no peculiarities, Chair, or there are no additional requirements in terms of auditing state-owned enterprises, because all the standards that requires you to look at applicable laws and regulations covers that, Chair.
And you'll accept, as you just have, that one of the key pieces of legislation for state-owned enterprises is the Public Finance Management Act, correct?
Chair, that would be correct.
So let me go back to the point you made just before you answered this question, because it seemed to me that it was suggesting that it might not be accurate to say when you audit public enterprise, there are additional requirements that are not there when you audit a private company. That's the impression I got from your answer. Is it a correct impression from the comment you made? Chair, when you said an audit is an audit.
Thank you, Chair, for the question. Chair, I think what I was trying to illustrate, Chair, is that we carry out our audit in terms of international standards of auditing. And even when you audit in the public sector, you still comply with the international standards of auditing. To the extent that there are initial requirements in the PFMA. It is not necessarily an initial requirement. It does not mean that the audit itself is necessarily different from what is in the private sector. It's more an, if I can use the term, Chair, it's more an industry issue. Different industries have got different requirements, and one would then look at the public sector as as an industry, and you say the PFMA is then the kind of regulation that you'd look at when you audit a public entity or a state-owned enterprise, as it is, Chair.
It may be that it's a difference without distinction.
Indeed, Chair.
Okay,
Because certainly the PFMA won't apply to a private company, isn't it? But it will apply to a lot of these SOEs that certainly this commission has been looking at, and government departments. But you seem to choose to look at it not as an additional requirement, but you simply you prefer to approach the matter on the basis that each industry or sector has got its own features. And when you are auditing an entity, whether private or public, in a certain sector, in a certain industry, you have an obligation to comply, to look at everything that applies to that sector. If it's a public sector, you would include the PFMA. If it's in the private sector, you won't include the PFMA, but depending on which sector it is, like insurance or whatever, there may be specific legislation applicable to that category of entities or that industry. And you, as an auditor, will have an obligation to apply your mind to all of the relevant legislation. That's how you approach it.
Yes, Chair, that is correct, Chair.
Yeah, okay.
Thank you, Chair. We're indebted for that clarification. I would then like to take you, Mr. Mothibe, to the PFMA, because there are a few provisions there that are going to form a backdrop to some of the questions today. Mr. Mothibe, you'll find that in the file that's been made available to you in this box of files entitled Aviation Legislation. Chair, we have dealt with that file previously. If I can just ask your registrar to assist you with the aviation legislation file. Chair and Mr. Mothibe, you'll find the Public Finance Management Act in that file commencing from page 4646.
Shall we identify this? I think is this is the file written Exhibit DD. Aviation legislation reference bundle on the SPY.
Thank you, Chair.
That's the file we are.
Yes, and it has been entered into the record previously.
Yes.
That's helpful. Thank you.
Yes,
and then
I
we
just want
commence.
to make sure that whoever reads the
Indeed.
transcript knows which file we are
Years
now talking
after,
about. Yeah.
we assume.
Yes, yeah.
And
Okay.
we start with the PFMA, which commences at page 4646. Mr. Mothibe, are you familiar with the provisions of this Act?
Chair, I have read the Act previously, and I'm familiar with some of the key provisions in the Act, Chair.
The first provision within the Act I'd like us to look at appears at page 50, and it's the definition of irregular expenditure. Could you read into the record what irregular expenditure is defined as on that page?
Chair, irregular expenditure means expenditure other than authorized expenditure incurred in contravention of or that is not in accordance with the requirement of any applicable legislation, including this Act or the State Tender Board Act 1968, Act number 86 of 1968, or any regulations made in terms of that Act, or any provincial legislation providing for procurement procedures in that provincial government.
Mr. Mothibe, do you understand from that definition that if a state-owned enterprise incurs expenditure which is not in accordance with the requirements of the PFMA, it will constitute irregular expenditure?
Chair, that is well understood, Chair.
Thank you. And then if we go to section 51.5.1, which you'll find at page 68. This is where we start to get to the substantive provisions of the PFMA that regulate state-owned enterprises such as SAA and its group of companies. And what section 51 does, Mr. Mothibe, and I'd like to confirm that this is also your understanding, is that it sets the responsibilities of accounting officers of state-owned enterprises such as SAA. Do you agree with that?
Chair, that is correct, Chair.
And amongst those responsibilities, could you tell us what the responsibility at section 51(1)(a)(1) is?
Chair, if I read it out, it says effective, efficient, and transparent systems of financial...
Your voice has gone down again.
I'll come closer to the mic, Chair.
Okay, all right.
Effective, efficient, and transparent system of financial and risk management and internal control.
So it's a requirement, is it your understanding that it's a requirement of the PFMA that an entity like SAA must ensure that it has and maintains internal controls?
Chair, that is correct.
And that it has and maintains an effective, efficient, transparent system for financial and risk management?
Chair, that is how the Act reads. That's correct, Chair.
And is it also your understanding that it's another obligation of the accounting authority for an entity like SAA to have and maintain, I'm now at Roman 3, an appropriate procurement and provisioning system which is fair, equitable, transparent, competitive, and cost-effective?
Chair, that is how the Act reads. That's correct, Chair.
And that's your understanding of it, is it, Mr. Mothibe?
Chair, that is my understanding.
Thank you. And who is the accounting authority for SAA?
Chair, that will be the board, and obviously the board may delegate it to the CFO and other relevant officials.
Would that happen by way of delegations of authority?
That would be correct.
And then if we go over the page to page 69, the other obligation or responsibility of accounting authorities, I'd like to just be clear that we're on the same page about, is the responsibility for the accounting authority to have and maintain, apologies, now we're on to B, I'm interested in B, so the accounting authority of a public entity, B, must take effective and appropriate steps to, Roman 2, prevent irregular expenditure. Is it your understanding that the board of SAA was required to do that as well?
That is correct, Chair.
Thank you. I'd then like to go to section 55, because that's actually the section I suggest slightly closer to home for you, because that is the section, you'll find it at page 70, Chair and Mr. Mothibe, 70, and it's section 55, which deals with the annual report and financial statements of public entities. And the one I'm interested in there, Mr. Mothibe, is section 55(2)(b). Section 55(2)(b) reads as follows: the annual report and financial statements referred to in one of the subsections above must, and B, include particulars of Roman 1, any material losses through criminal conduct, and any irregular expenditure and fruitless and wasteful expenditure that occurred during the financial year. Do you see that?
I see the section, Chair.
And Mr. Mothibe, is it your understanding then that when you are, as an auditor, reviewing the financial statements of a public entity such as SAA, one of the things you're going to be looking for is whether those financial statements comply with this requirement at B, that they include particulars of any irregular expenditure?
That would be correct, Chair.
And any fruitless and wasteful expenditure must also be disclosed in those financial statements, mustn't it?
That would be correct, Chair.
And there would be non-compliance with the PFMA if the financial statements did not reflect that, correct?
Chair, that interpretation is correct.
And would you also accept there would be non-compliance with the PFMA if the accounting authority, the board of SAA, permitted procurement to take place in a manner that was not fair, equitable, transparent, competitive, and cost-effective?
Chair, that interpretation is correct.
Thank you. Now, Mr. Mothibe, we received some evidence from Mr. Sokumbela about the approach that the Auditor General took to its auditing of SAA and its group of companies in 2017. And he gave the chair and the rest of us some detailed insight into how they went about determining whether irregular expenditure had been incurred and its extent in the 2017 financial year. I'd like to ask you, before I go to what he said, to tell the chair and us how you approached that aspect of your audit responsibilities for the years 2014 to 2016.
Thank you, Chair. I'd like to also refer the Chair to my initial statement, Chair, where we indicated the work split between the joint auditors, and to confirm that in the years for the years ending 31 March 2014 and 31 March 2015. That part of the work was performed by the joint auditors. However, Chair, I can talk to certainly the principles that guided the approach. And for the 31 March 2016 year, Chair, the work was performed by my team, PwC. So obviously, Chair, I'll talk to that, and also to confirm, the Chair, that the approach was fairly consistent for the 3 years under review. Chair, South African Airways has got a compliance office, and in obtaining and confirming our understanding of the business processes and the different matters that they've got to consider, we do sit with the compliance office, and one of those areas that we engaged them on is how the systems they've got in place to identify and report irregular expenditure and fruitless and wasteful expenditure. Chair, we reviewed that process, and in addition, Chair, there will be work performed in the area of procurement and contract management, which should help us to confirm the review that we had done from the compliance side. So part of it, Chair, of the approach includes understanding the controls that exist at the entity, how they report, should management be comfortable with what they put into place, and then the substantive work that we do in the procurement and contract management area would help us to confirm that that everything was done as expected, Chair.
You and your joint audit partner, Nkonki, for the years 2014 to 2016, were satisfied that the internal controls were adequate, weren't you?
Chair, I think I should refer the Chair to our supplementary statement that we had submitted, Chair, where we do confirm that from that we performed, we did identify deviations, and we did notify management and those charged with governance of the deviations. And so, Chair, to the extent that we did not elevate that part of it to the audit report as required, Chair, we do, I think, what is the correct word, Chair? Chair, we do accept that we should have done that. So, Chair, whilst the controls were implemented, they did not identify all the issues. We picked up deviations when we performed our work. We informed management. We informed the audit committee that was charged with governance. But we did not complete the final step. And hence the concession that we have made, Chair, in that supplementary statement.
Mr. Mothibe, you've come to that concession between February and July this year, is that correct?
That is correct, Chair.
Because your first statement before this commission, before the evidence of Mr. Sokombela, you did not make that concession, did you?
Chair, at that time, Chair, I had reviewed the work that was performed. I had considered what was required of us, and it was my view then, Chair, that we had done sufficient. Chair, subsequent to the initial statement, Chair, I did go back. We did go back to the PFMA. We did go back to our records, and we considered what was required of us in terms of the R3 guide from the Office of the Auditor General. And Chair, it became clear that we had erred, and we should have elevated some of those items of non-compliance, Chair, to in the audit report. But Chair, I think it is important to note that those items that we did identify were elevated to management. We sought their responses in that regard, and those matters were elevated to the audit committee, those who were charged with governance.
Mr. Mothibe, I will be returning to this topic. At the moment, I'm still setting the sort of background of your understanding of the audit. You see, Mr. Sokombela indicated that what his team did when they moved in for the 2017 audit, in order to satisfy themselves as to the disclosure of irregular expenditure in the financial statements, is quite a detailed exercise. He said they would review tender files, let me add when they could find them, because a substantial part of his evidence was also that they simply could not find whole reams of the contracts which they were required to audit. He had to send teams in to try and locate documents because on his version, the state of internal control was in disarray. But when he was able to find complete tender files, I was very interested in the language he used. He said they would re-perform the awarding of those tenders. That's how seriously he took the obligation to satisfy himself that the figure that he's seeing in the financial statements for irregular expenditure is accurate, is verifiable. Did you do anything of that sort?
Chair, as part of the audit, and in order to comply with the PFMA, we have to perform work on procurement and contract management. Chair, that work was performed. As I indicate, Chair, not only was the work performed, we found deviations, which we reported up to management and to the audit committee. So, Chair, I cannot comment on the amount of work or the challenges that Mr. Sokombela experienced when he performed his audit. Because as you'd appreciate, Chair, it was months after we had been there. So, Chair, a lot can happen in that intervening period. However, as I indicate, Chair, from the work that we performed on procurement and contract management, we did find deviations which we elevated to the audit committee and raised a consensus with management.
I think Ms. Hofmeyer's question is aimed at establishing whether your approach to the performance of these duties may have been the same as that of Mr. Sokombela?
Yes.
Yeah, because Ms. Hofmeyer is saying, Mr. Sokombela said the way they approached it was that they looked at the files and effectively, as I understand the position, said, would we have done this? Is this the right way to do it? And in terms of tenders and bids. So she seeks to establish whether you also adopted the same approach or did you adopt a different approach? That's what she seeks to establish.
Chair, I can confirm that the approach was guided by the regulations or the R3 guide, the guide that we received from the Office of the Auditor General on how you perform work on procurement and contract management. So the approach would have been the same. Chair, what would certainly be different would have been, for example, the size of samples that one would have selected. And Chair, the challenge with audit sampling is that one of the inherent limitations is that you can come in, select your sample, and find few or no deviations. A different auditor or person coming, selecting a different sample, the outcome would be fairly different, especially considering the size or the number of contracts that exist at a place like South African Airways, Chair, fairly big numbers. So, Chair, I cannot comment on his sample size, but certainly I can confirm that we did receive the guidance from the Office of the AG and we followed that guidance, Chair.
Ms. Mothibe, the question had nothing to do with sampling. I'm going to come to that because I know it's a big part of your evidence today to distinguish different samples. What I was interested in and what the chair confirmed was, did you adopt the method that Mr. Sokombela adopted? Did you go and find tenders that had been awarded and re-perform the award of those tenders? And by that he meant go and get the file, see how the bid started, see how it was responded to, see how it was awarded, see whether the person who eventually awarded it had the requisite delegation of authority. Did you re-perform the awarding of the contracts that you determined necessary to audit?
Chair, insofar it was in line with the guidance that we received from the Office of the AG on how to audit procurement and contract information, that is correct, Chair. That is the approach that we took.
Well, I'm concerned about the qualification. You said insofar as it was in line with. So I think what Ms. Hofmeyer is looking at is, let me assume that whether it's sampling or whatever, leads you to a certain contract that SAA awarded to Mr. Mothibe. Okay,
Yes, Chair.
so you want to look at how that contract was awarded.
Yes, Chair, that is correct.
Would you, once you have identified that contract as one of the matters that you must look at, would you then go through the various stages or requirements to say SAA was required to do A, B, C, D for this contract to be said to have been awarded properly? Did they do A, B, C, D properly? And if you then concluded that that was done properly, then you say, okay, I've taken care of this. Or would you, for example, despite knowing that SAA was supposed to do A, B, C, D, would you just look at A and B, and if you are happy with A and B, you don't look at C and D?
Chair, what you have described, in order to understand what Ms. Hofmeyer is looking for, we have done that, Chair.
You did that. So you would look at A, B, C, and D,
Yes,
so
Chair.
to speak. Okay, all right. I hope that has
Thank you.
helpful.
It does. Ms. Mothibe, how did you do that if you couldn't find the tender files?
Chair, as I indicated, Chair, for the samples that we had selected, we followed that through. And where there were challenges and there were deviations, we found them and we raised them with management and with the audit committee, Chair.
Does that suggest that you found files in regard to all the contracts you looked at? Because I think Ms. Hofmeyer's question is, how would you have looked at A, B, C, D in my kind of example if you did not find the files?
Chair, thank you, Chair. Chair, if one looks at the report that we sent through to management and to the committee, we did mention areas where we could not be provided with files, and therefore we would obviously not have been able to complete that process. Hence, Chair, I do indicate we followed the guidance on how to perform the audit of procurement and contract management. Where we found the files, we obviously able to perform every single test, but there were areas where we could not be provided with the files. And so the test failed, and we reported that matter to management. We asked them to follow up, and we reported the matter to the audit committee.
Would it be correct to say, without the files, you couldn't perform that job? Your job as an auditor?
Chair,
properly?
Yes, Chair, without the file, then you are not able to complete all the
Yes.
necessary steps. That is correct, Chair.
You can comment about the absence of the file or not being provided by the file, but you can't actually do what you are supposed to do without the file. You can't perform the actual job that you wanted to do.
Chair, that is correct.
Yes.
And it was for that reason that we elevated, we raised the issue with management, and we elevated the matter to the audit committee. And Chair, I think as I allude to in our summary statement, we acknowledge that we should have, there was that next step of, in the audit opinion, mentioning those non-compliance issues with the PFMA.
Ms. Hofmeyer.
Yes, it's that step that is quite an important one, isn't it, Mr. Mothibe? Because it's one thing for you to need to do the work that's required of you, to find that you're inhibited in doing that because you can't find tender files, to report that to management and the Audit and Risk Committee, but then not take it any further. That would be a dereliction of your duty, wouldn't it?
Chair, I would not go as far as to say it's a dereliction of duty, because we certainly there are reporting steps that we're able to carry out, Chair. And as I do indicate, Chair, we did consent to the fact that that last step should have been carried out. That
Yes,
is
but-
identifying the matter in the audit opinion.
Yes, but if it was your duty to do that last step and you didn't do it, why is that not a dereliction of duty? Because I think you don't concede to Ms. Hofmeier's question that when she asked, was it not a dereliction of duty? So my question is, since you do accept that that last step should have been done, and it wasn't done. So my question is, which is basically Ms. Hofmeier's question, why was that not, why do you not regard that as a dereliction of duty?
Chair, can I think about that? Because I guess, Chair, I'm trying to wrap my mind
Okay.
around
No,
what exactly the direction of duty, because it could
Yes.
it could mean something else, Chair.
Okay, well,
I'd like to wrap my
no,
mind around that, Chair.
that's fine. Ms. Hofmeier can come back to it later on if, yeah.
See, the problem with that last step, Mr. Mothibe, I'd like to put to you and have your comment on, is if you don't focus on and perform your duty in the last step, then your audit opinion is going to be incorrect, isn't it?
Chair, the audit opinion, insofar as it talks about compliance with laws and regulations, Chair, would be incorrect.
Because you can't satisfy yourself that there's been compliance because you haven't got the tender file. And although you've reported it to management and ARC, the Audit and Risk Committee, you didn't receive any meaningful response to that, did you?
Chair, in performing the work and in identifying the issues and elevating them to the audit committee, we had already identified that it is in fact non-compliance with the PFMA. As I do indicate, Chair, that last step is what was missing. That's where we erred in not informing the shareholders in that regard.
Ms. Hofmeier, please don't forget your next question. I just want to go back to the dereliction of duty aspect. If we don't call it dereliction of duty, but call it omission of duty, are you comfortable to concede that?
Chair, it was an omission.
It was
Chair.
an omission
It was
of
an
duty.
omission.
Okay, all right. Thank you. Ms. Hofmeier, that doesn't preclude you from coming back
Of
to the
course.
question, but I thought I would, yes.
Thank you, Chair. Chair, I note that we are close to the tea break, but I would like to just conclude on one point, if I may. Ms. Mothibe, I understood your last answer before the Chair's question to be that you had identified non-compliance. You'd raised it with management and the Audit and Risk Committee. But then I want to put to you, if that is so, and you aren't satisfied that there has then been compliance because of the response you get, it is then misleading to the public, is it not, to sign an audit report which says that there has been compliance. We do not identify any instances of material non-compliance with applicable laws and regulations. Do you accept that?
Chair, after we've completed our work, when we put our audit opinion together, we considered all the evidence that had been provided for audit purposes and applied judgment on some of these issues of non-compliance and other matters, in fact, Chair, in the audit as a whole. And at that stage, Chair, our view was that there was no material non-compliance. And I think, Chair, it is important to note that we're not saying that there was no compliance. I guess, Chair, we say that there was no material non-compliance. Chair, again, I would refer one to the supplementary statement, because we do concede that there was an error in judgment. We should have identified those matters as material areas of non-compliance.
Yes, and so then when you stated in your audit report, we did not identify any instances of material non-compliance with applicable laws and regulations, that was misleading.
Chair, that portion, Chair, was not correct, Chair, yes.
Thank you, Chair. I see we're just at 1:15, if it's a convenient time to take the break.
Yes, we'll take the short adjournment. We'll resume at 11:30. We adjourn.
All rise.
Chair, as I did indicate in my statement, the appointment of PwC and Kongi predates my my joining the South African Airway or rather PwC audit team. When I took over the assignment, I understood that the award was for 5 years, but also understood very well that it is subject to annual concurrence by the Office of the AG and confirmation at every annual general meeting by the client, because the client reserves the right to review the appointment, Chair.
But I think Ms. Hofmeyer's question is whether, as you sit there today, you accept or you don't accept that the appointment was for 1 year. So distinguishing it from what you may have understood when you joined the team.
Chairman, the award letter said 1 year, and Chair, from my understanding, it's 1 year because it had to be renewed on an annual basis, but the term would have been for 5 years. So the appointment has to be confirmed by the client at the AGM and has to seek concurrence from the Office of the AG.
So is your evidence that you don't accept that the appointment was for 1 year?
Chair, I'm not too sure that one can read that letter as plainly as that, because my understanding, Chair, is that they have to. You can't appoint for more than 5 years, for more than 1 year. You have to seek concurrence and approval at every AGM. So the appointment letter would, as I understand it, Chair,
yes,
would list that 1 year that you appointed, and then once there's concurrence and approval, then another one that confirms the next year, as it is, Chair.
I think Ms. Hofmeyer will take us to the actual letter, and then, yes, Ms. Hofmeyer.
Thank you, Chair. Ms. Mothibe, I had hoped that we would be able to move through this quickly, but it appears that we're not going to be. Do you know that the request for proposal to which PwC responded related only to an audit for the 2012 financial year?
Chair, maybe if Ms. Hofmeyer could give me a reference to the file.
Yes.
Let's find it in, it's in DD 19C, as we've now numbered it, from page 59.
I've got it, Chair.
Now, that is a document, as appears at page 59, bid document, request for proposal for the provision of external audit services to SAA Group. Do you see that?
I see that, Chair.
And then if you turn to page 77, you'll see there the scope of work is identified. Do you have that?
I see that, Chair.
And in the second, it tells you that the objective of the audit as a statutory requirement is the expression of an opinion on fairness in all material respects of SAA's financial statements in conformity with international financial reporting standards. And then the second sentence says the audit for the financial year ending 31 March 2012 have to be conducted in accordance with the international standards on auditing, and then it gives you the focus areas for the audit for the financial year ending 31 March 2012. Do you see that?
That is correct, Chair.
Do you now accept that the request for proposal related to the audit for the financial year ending 31 March 2012?
Chair, that's how it reads, Chair.
You accept that, and then that was followed up by the award letter to PwC that was clear on this point. You'll find it at the same bundle, page 115.
I've got it, Chair.
This is a letter of award to PricewaterhouseCoopers from the Chief Procurement Officer of South African Airways. It is dated 21 December 2011. Please can you read the first paragraph of the letter into the record?
The one that starts with reference to the above.
Yes, indeed, thank you.
With reference to the above request for proposal, South African Airways Limited, SAA, would like to congratulate PricewaterhouseCoopers on being awarded the above services as joint external auditors within Nkonki Incorporated for our 2011-2012 financial year.
That is an award for 1 year, correct?
Chair, that's how it reads.
Yes, so do you now accept that PwC and Nkonki were only appointed for a single year after the tender process that preceded this letter?
Chair, that's how the letter reads, but I do believe it is important to note that companies don't change auditors annually. And from our understanding as PwC, certainly was that the audit engagement would be for a period of 5 years. Chair, it is not economically viable, certainly from our side, to respond to a tender, audit tender of this size, of this complexity, if it was only going to be performed for a period of 1 year. In the first year of engagement, Chair, there's a lot of investment that takes place with regards to understanding the client, the complexities that come with it. And Chair, as I do indicate, from a commercial perspective, you certainly would not be responding to an RFP of this magnitude if it was only for 1 year. Also importantly, Chair, running a tender process for audit services on an annual basis takes a lot of time, not only for respondents, but also for the client. And Chair, it would be very disruptive for a client to be engaging with new auditors every single year. As you appreciate, Chair.
Yes, Mr. Mothibe, I think both Ms. Hoffman and I understand what you are saying. I think another witness has said something similar. But the question is, irrespective of whether you consider it viable or not viable for an entity such as SAA to appoint auditors for 1 year, the question is whether you accept that in this case, the appointment was for 1 year, right or wrong, but that's what happened.
Yes, Chair, that I've agreed to, Chair. I thought it was important just to bring some perspective, Chair,
yes,
to the matter.
That's fine.
Ms. Mothibe, then I would like to just pick up on something you were saying in that context setting. You, as I have it, you said something like, it would not make sense for PwC to respond to an RFP of this magnitude if it was not for something like a duration of 5 years. Did I have your evidence correct?
Chair, what I mean is that any audit firm, I spoke PwC because obviously, Chair, I do work for PwC, but I would say it would not be commercially viable for any audit firm to respond, especially for a company this size, this magnitude, and this complexity. It would just be not viable if it was only for a period of 1 year.
Then why did PwC bid for 1 year?
Chair, goes back that our understanding was that it would have been for a period of 5 years, which is in line also with the rotation period of a partner as laid out in the Companies Act, Chair.
Mr. Mothibe, how did somebody in PwC read a request for bid confined to 1 year, receive an award letter for 1 year, and form the view that it was getting to do audit work for 5 years? How does that happen?
Chair?
So in other words, what's the basis for you or PwC to have thought that this was for 5 years when the request for proposals was talking about 1 year and the letter of appointment was talking about 1 year?
Chair, as I indicated earlier, this was predated my involvement. However, Chair, it is standard practice, or it is practice that when you get an audit or an audit, it is for a period of longer than 1 year. We have not seen, Chair, anywhere where an audit was awarded for 1 year only, Chair. That doesn't happen in practice, Chair.
Ms. Hofmeyer?
Do you think PwC bid for 1 year and hoped it might be able to get extensions of that 1 year?
Chair, as I do indicate, we are also alive to the fact that to the extent that the subsequent years audits are with PwC, they will still be subject to concurrence by the Office of the AG and confirmation at the AGM. So there is still a process that is followed in that regard.
And what about the process of lawful procurement? Wouldn't PwC have to subject itself to another procurement process if all it was appointed to do initially was 1 year?
Chair, the procurement process is run by South African Airways and not by PwC. Chair, so I'm not too sure I can speculate on that regard, Chair.
Well, you said that, I'm putting it in my own words, I'm paraphrasing what you're saying, that there was going to be, or there were going to be annual renewals. So the question then is, shouldn't those renewals have been subject to a open public tender? And I think your answer is SAA would run that, but I think Ms. Hofmeyer probably wants to follow up on that.
I agree it's for SAA to run the process. What I'm trying to understand is PwC's thinking, because your evidence before this commission is it's not commercially viable for audit firms to bid for only 1 year's audit. Is that correct?
Yes, I said on this magnitude, and it is something that we don't see in practice.
Yes. And then I said, well, how then did PwC go about its approach here? Because it bids for 1 year, it gets awarded for only 1 year. And I've asked you, did it think it would simply be able to extend each year or get appointed for further years? And I understood your answer to be yes, because there's a process where the Auditor General has to yearly confirm his agreement with that appointment. Do I have your evidence correct?
Chair, as I indicated, the areas here which predate my involvement, but certainly the understanding was that the audit was for a period of longer than 1 year, subject to approvals.
Yes, but do you accept that
I'm sorry, I'm not sure that I understood that. Just repeat that last point.
I was saying, Chair, that my understanding, as I indicated, was that the award of the audit was for a period of longer than, not 1 year, but 5 years, and however, it will still be subject to approvals. And we do take comfort in the fact that the Office of the AG gave concurrence after the company appointed PwC and Nkonki at its annual general meeting.
Mr. Mothibe, do you accept that when a state-owned enterprise like SAA appoints an external auditor, it is procuring services?
It is a recurring service, Chair.
And do you accept that the procurement of services by a state-owned enterprise like SAA must be preceded by a tender process?
Yes, Chair, which tender process was entered into in 2011 that we responded to?
Yes, for a single year, Mr. Mothibe. Is that correct?
Chair, I shared with Ms. Over my understanding of what it was.
Maybe please don't forget your line of thinking, Ms. Hofmeyer. Let's put this to bed if we haven't done so. by which I mean, let's see whether there is agreement exactly on what the position was. We now know that the request for proposals was for one financial year, 2011, 2012, okay? And you accept that. But you say, if I understand you correctly, you had an understanding. You had an understanding that the appointment was for 5 years.
That is correct, Chair.
Subject to annual approvals or renewals. Is that right?
That's correct, Chair.
Now, where did you get this understanding from that the appointment was for 5 years when the request for proposal said 1 year, the letter of appointment said 1 year?
Chair, if you recall, I did indicate I was not part of the process. I became part of the audit team for the 2014 financial year. So we had already signed off jointly with Nkongi the 2012 and the 2013. So as part of the handover process, we discussed, we spoke about what our duty and our mandate was, and so it was confirmed that our understanding was that we were appointed for a period of 5 years.
So your understanding is based on what the team, the PwC team responsible for auditing SAA conveyed to you at the time?
And Chair, also what we have experienced, what happens in the industry.
Okay, well, one, certainly the team, the PwC team that was assigned to SAA conveyed that to you, that's number one. Number two, you say there's a practice in the industry that also informed your understanding. Is that right?
That is correct, Chair.
And what is that practice?
Chair, that typically when you appoint auditors, it will be for it would not be, certainly not for a period of 1 year only, Chair. And importantly, there is that annual reappointment approval at the AGM, annual general meeting of the company, which is a requirement of the Companies Act, Chair, that happens.
Is your evidence that the practice in the industry is that an auditing firm would be awarded a job such as this, and on paper it would be written 1 year, but everybody else knows that it's not going to be for 1 year, it was going to be for 5 years or 3 years? Is that what you are saying?
That is my understanding, Chair. That is what I'm saying, Chair.
So even if the entity makes it clear that this is for 1 year, you would take that you have been awarded a contract for 5 years?
Chair, I would think there would also be discussions with the entity. Once you were appointed, you obviously would be engaged with the entity to understand the exact mandate, how long it is. But as I indicate, Chair, as the letter stands, I do agree it says 2012, because, and I do believe it should be because there is a requirement to have an annual reconfirmation by the AGM and by the AG.
Ms. Mayor.
Mr. Mothibe, I want to move you to a new document in a moment, but I just want to understand this practice in the industry. Is that a practice related to private companies or to state-owned enterprises?
Chair, even with private companies, we would an audit firm would not respond to a request for proposals if the appointment would only be for 1 year. That would not happen, Chair.
Let me be clearer with my question. I can completely understand in a private company context why it would be the case that even though you're appointed for 1 year, you have some reliance on an industry practice that at the next annual general meeting you'll be appointed again. That is private companies. State-owned enterprises are regulated by the PFMA. They have to go out on tender before they procure services. And I'm trying to understand whether the industry practice to which you speak is also an industry practice for the state-owned enterprises who need to be audited. Do they generally roll over their audits when they go out on tender only for 1 year? Is it your experience that they continue to extend those?
Chair, I have not seen even the state-owned enterprises that that keep auditors only for 1 year. I have not seen that, certainly, Chair.
My question is different, but go ahead, Chair.
Okay.
Maybe you go back to your question before I ask.
I want to understand this practice because it's quite important in the state-owned enterprise context. Are you aware of a practice whereby state-owned enterprises run tender processes only for a year, but it is understood by the industry that that is for a longer period of 3, 4, 5 years?
Chair, I'm not too sure if I can answer that question because I can talk to requests for proposals that I had responded to.
Let me put it this way. You talked about a practice that you understand to be there in the industry. Okay.
Yes, Chair.
So Ms. Hofmeier's question is whether that practice that informed your understanding,
Yes, Chair.
does it apply to state-owned enterprises? Or is this a question of you may have been aware of a practice that applies to the private sector, but you invoked it in the context of a public enterprise without knowing that in the public sector, without knowing whether there is such a practice in the public sector?
Chair, apologies for the delay. I'm just trying to reflect on what one has observed, Chair. Chair, I do believe even in the public sector, an appointment of 1 year is, as I indicate, it's not one that I had seen, Chair. I have not seen that. And the expectation.
Yes, but the question is about the practice. So in other words, as you sit there, are you able to say this practice that I'm talking about exists in the public sector as well? Or is your position that you are not sure whether it exists in the public sector, but you know that it exists in the private sector? Is it the latter?
Maybe I have to say the latter, Chair.
Okay, all right.
Ms. Mothibe, you made the point earlier, procurement is the responsibility of SAA, and I readily accept that. But what I'd like to just draw your attention to is that it is customary for SOEs to devise tender processes for the appointments of their auditors for 5 years. I suspect for the very reasons you've given, right? And the reason I say that with confidence is because we in our investigations have been able to find one of the tenders that Eskom put out, for example, in 2015 for its audit services, and you'll find that in DD 19C at page 149. Let me just be clear, it begins at page 143. It's the Eskom RFP. For audit
did you say
services.
149?
It starts at 143, Chair, just so that we can identify the document.
Okay.
This is the November 2015 ESCOM RFP for professional services, including audit services. And if you go in it at page 149, I won't bore you with all the details of this RFP, Mr. Mothibe, but it is an RFP for professional services, including audit services, and at paragraph 4.3 on that page, there are stipulated additional conditions of tender. And what ESCOM does here, I suspect you might say, is sensible, because ESCOM says the appointment will be made for a period of 5 years relating to the audit of 5 financial years, from 2014 to 2015 financial year onwards, subject to the following conditions. And if you go to the last of the bullets there, this is the point that you've emphasized about the Auditor General. What ESCOM does is it says the final condition is there must be annual consultation with the Auditor General before the appointment for a specific year is finalized. Do you see that?
I see that, Chair.
So what I put to you is there is a way for state-owned enterprises to procure the services of auditors for more than 1 year, and I'm suggesting this is an example of that. Do you accept that that's so?
Chair, this is a good example, Chair.
And it should be contrasted, I put to you, with the request for proposal that went out from SAA in 2011, because SAA's 2011 request for proposal looked nothing like this, did it?
The SAA RFP did not contain this clause, Chair.
And Mr. Mothibe, you said that when you came in 2014, and I'm mindful to the fact that you were not there from the beginning, but when you came in 2014, you were led to understand that this was an appointment for 5 years. Is that correct?
That's the understanding that I had, Chair.
Yes. And you got it from your team, is that right?
That is correct, Chair.
And as part of the audit procedures that your team were following, were they reviewing BAC minutes and board minutes in the course of their audit procedures?
They would have done so, Chair.
So do you know why they didn't pick up a bid adjudication committee minute in 2012 that raised concerns about the fact that the appointment of the auditors for the 2013 year had not gone through a procurement process?
Chair, I was not part of the team in 2012, so I cannot comment on that, Chair.
In preparing for your evidence today, have you raised any questions with your colleagues about why they might not have picked that up?
Chair, as I did indicate, remember, Chair, we said that our understanding was that it was for a period of 5 years. So if one thinks about it, Chair, there would not be any adjudication because the audit would have been for 5 years, as we understood.
Well, you might have misunderstood the question.
Yes, ma'am.
The question is whether in preparing for giving evidence today, you did pick up that the PwC team did not pick up the issue of there having been no open tender. Or unless I misunderstood then your answer, maybe you are saying your answer is you couldn't have picked that up because your understanding was that it was for 5 years, and if it was for 5 years,
It wouldn't be there.
the tender that had been done at the beginning would be applicable for all the years.
That is correct, Chair.
Okay, all right.
So what I'm trying to probe at the moment is how your team formed this understanding that it was for 5 years. Because part of the audit procedures is to look at minutes, right? And I want to now take you to the bid adjudication committee minute that appears in DDC at page 117. This is, Mr. Mothibe, do you have it?
I have it, Chair.
This is a decision record of a meeting of the Bid Adjudication Committee of SAA dated the 7th of December 2012. Do you see that at the top of the page?
I see that, Chair.
And in the second block on that page, there's a heading Project Description or Purpose. And what it records there, I'll just read it into the record, is to notify the BAC of the support and recommendation by the Audit Committee to the SAA Board of Directors of the extension and reappointment of PricewaterhouseCoopers and Conky Incorporated as the joint external auditors for the SAA Group, excluding Mango Airlines, for the 2012-2013 financial year, at an estimated cost of 16,838,850 rand. Do you see that?
I see that, Chair.
Now, that's the year after the year for which the tender process was run, correct?
That is correct.
And your team, as I understand the procedures, would have been looking at these minutes amongst others. And what I want to understand from you is how they could have missed what is reflected at the bottom of that page under the heading Conditions or Follow-up Actions. That's written in hand, and I'll read it into the record. BAC noted that the normal defined and approved procedures in line with SCM policy and DOA was not followed. The head of GSM should escalate to the internal audit as the process was not correctly followed. BAC aware that this has been approved by the AGM and supported by the Audit Committee, business should clarify the original contract period and provide additional information on the process followed. How did the PwC team miss, when it was going through these minutes, this recordal, do you think?
Chair, this minute predates my involvement, so I'm not too sure that I'm able to do that. If I respond, Chair, I would be speculating.
Yeah.
And if I'm allowed to speculate, Chair,
Yeah.
it might be because it did not form part of their sample. Because once you do review minutes, and you review minutes and you pick up, you do pick up items from minutes that you'd want to audit. There's different criteria that you use to pick them up, and it could be that this matter, as related to the work that happened, was not part of the sample that they've looked at. But Chair, as I indicated, that's speculating, Chair.
Yeah, no,
it's not fair to do so, Chair.
That's fine. Let me ask this question. Bearing in mind that you were not there at the commencement of PwC's involvement at SAA, I take it that the team would not have started the work without the PwC team, would not have started the work without having seen the letters of appointment, or at least the leader of the team. Is that right?
That's correct, Chair.
Yes. And now that we know that the letter of appointment made it clear it was for one financial year, sitting there, are you able to understand how somebody who would have seen that letter saying 1 year would say to you, we have been appointed for 5 years? Now, I'm not suggesting that the person who told you is the leader of the team, but I'm just assuming that at least the leader of the team would have seen the letter of appointment. If he had seen the letter, would you have any understanding how he would say, or anybody who had seen it would say to you, we have been appointed for 5 years? You might be able to say, I don't understand why anybody who had seen the letter would tell me it's for 5 years. Or you might say, because of A, B, C, D that I'm aware of, I can understand why somebody who had seen the letter would tell me that the appointment is for 5 years. That's what I'm interested in.
Yes, Chair, I understand your question. Chair, the appointment was for 2011-2012, the initial letter. Subsequent to that, there was another appointment for the year 2012-2013. So when I became involved, we had also already been appointed for 2013-2014. Because as I did indicate, Chair, I only joined the team halfway during the 2014 financial year. So, as you can appreciate, Chair, with the passage of time and with the subsequent appointments post the first one, I can understand why the view was that it was a period of 5 years, because that appointment, the initial appointment, had been reconfirmed for another 2 years, Chair.
But if one is basing the statement that PwC was appointed for 5 years on what you are saying, it wouldn't be on the basis of the letter of appointment, isn't it? Saying that PwC was appointed for 5 years could not be on the basis of the letter of appointment. It had to be on the basis of something else, because the letter of appointment was quite clear.
Chair, a letter of appointment is issued on an annual basis, Chair. So for the subsequent year, there would have been another letter issued confirming appointment, same as all subsequent years, Chair.
Yes, but let's take it step by step. Do you agree with me that the letter of appointment to which we have made reference earlier on, which said 1 year,
That is correct, Chair.
could not form the basis for anybody to say PwC was appointed for 5 years? If there was a basis for saying that, it must be something else, not the letter. You agree with that?
I hear you, Chair.
Yes. And I seem to understand you to say there were annual letters of appointment, or I don't know whether that's what you would call them, every year. Now, would those annual letters be the basis for anybody to say PwC was appointed for 5 years?
Chair, as I indicated, that was my understanding. And Chair, those further appointments, if anything, they would confirm the understanding that we were certainly appointed for a period of longer than 1 year.
Because you see, if reliance is placed on those annual letters, I would imagine that what would happen is that somebody would say, well, we have been appointed 1 year at a time. Every year we get appointed. So the duration of appointment is no longer than 1 year at any time. In other words, this year, our obligation is for this year. Whether we will have any obligations, any job in regard to SAA next year, we don't know. We will know when we have been given another letter. Would you go along with that?
I do understand you, Chair.
Okay, thank you.
And then just to return to the BAC committee record, I understand you to say it might have been missed because it wasn't in a sample. You don't know that as a fact, do you?
Chair, hence I indicated it's because this predates my involvement. It's difficult for me to respond to a question like that, Chair. Whatever I say would amount to speculation, Chair, which I don't believe it's fair on the persons.
If you'd seen a minute like this, would you have been concerned that the appointment of PwC and Konki since the 2012 financial year was irregular?
If I saw this, I would be concerned. That's correct, Chair.
And would you accept that the appointments for the 2013 to 2016 financial year then would have constituted irregular expenditure under the PFMA?
Chair, based on the understanding that Ms. Homer has, that would be the case. But certainly, Chair, based on the understanding that I had, because the understanding was that it was a period of 5 years, I wouldn't have thought so, Chair.
But with your knowledge now, you accept that it did constitute irregular expenditure?
Chair, without seeing how this matter was finalized, because there's an issue raised here, I'm not too sure that one is able to respond to that. Secondly, Chair, also appreciating that where there's irregular expenditure, there is an opportunity for the entity to regularize it. And having not seen what they would have done to correct the matter, I'm not too sure I could respond to that, Chair.
Let me, in fairness, break it down. We've accepted in your evidence that the procuring of audit services is procurement that must comply with the PFMA for an entity like SAA, correct?
That's correct.
We know that they tended to provide, to obtain audit services for the 2012 financial year, correct?
That is correct.
We know that they did not tender to receive audit services for the years 2013 to 2016, correct?
Chair, you said there was no official tender process run by SAA.
Yes. And we know that procurement not in conformity with the PFMA constitutes irregular expenditure, correct?
That is correct.
So then I put it to you again, the appointment of PwC and Nkonki for the 2013 to 2016 financial years therefore constituted irregular expenditure, correct?
Chair, that would be correct to the extent that there was no process put in place to regularize it.
And do you know what PwC and Nkonki were paid for those 4 years of audit work that constituted irregular expenditure?
Chair, I don't have the amount at the top of my head, but it is included in the pack, Chair.
I will assist you if you're willing to trust my calculation abilities, Mr. Mothibe, because I've taken each of the payments that we received from SAA for the 2013 to 2016 years, for each of Nkonki and PwC, and I've added them up, and the total I got to was 69,760,888 rand. Does that sound right?
Mr. Mothibe, I would just warn you not to be very trusting of lawyers' calculation.
Mr. Mothibe, let's do it this way. Over the lunch break, I'll direct you to Ms. Olitsky's affidavit. As I tally them up, it's 69,760,888 rand.
If you say so, ma'am.
Thank you. And if over the break, let me just give you the reference so you can go there. Her affidavit is in DD19C at page 49. If over the break you establish that I've made a calculation error, you can let us know after 2 o'clock. Are you comfortable with that?
Chair, I'm comfortable.
She probably got it right.
Well, I'm not always sure with calculations, but
you must check.
it's in the order of 69 million, I suggest.
I will trust the Chair.
Yeah, okay.
So that 69 million of irregular expenditure didn't get disclosed in the financial statements for the years 2013 to 2016, did it?
Chair, at this stage, and based on understanding, because we did not believe it to be irregular, it had not been disclosed.
Thank you. Mr. Mothibe, I'd like to move...
I'm sorry. If PwC believed that it had been awarded a contract for 5 years, it had been appointed for 5 years, that the request for proposals told competitors and others in the public that whoever was going to be appointed would be appointed for 1 year. And if PwC as they continued every year to do this work, that they were performing work in circumstances where there was irregularity, because the request for proposals and the letter of appointment said 1 year. It didn't say 5 years, and yet they were continuing every year.
Chair, as I indicate, much as the letter said 1 year, the understanding would have been that it was a longer period. We have never been in an environment where we saw an appointment of auditors being done for 1 year only. So
Yes, no, I understand. I understand that. I'm sorry to interrupt you. I understand that. But my question is, you ought, as PwC, I would imagine, you ought to have paid some attention to whether you were performing these duties under a regular arrangement, under a lawful appointment. And a lawful appointment, you would have known, must have been that if the invitation, the request for proposals said it's for a certain period, and you competed with your competitors, with other people, and you competed for one period, for a period of 1 year. When you get to continue and do the work beyond that period, it must be irregular. Because your competitors, call them XYZ, who let us say, well, I don't know how many bidders there were, but let us say there were 2 bidders, and you succeeded. XYZ was another bidder. They didn't succeed. So as far as they are concerned, you got a tender for 1 year. Now they hear that 2 years later you are still there, 3 years later you are still there, 4 years later you are still there, but they've been watching for any new tenders issued by, or requests for proposals issued by SAA. They must feel aggrieved to say, but these people were appointed for 1 year. Why are they continuing? Why are we not given an opportunity? What's happening? And I'm suggesting that as PwC, that ought to have been a concern to you as PwC, because you knew that the letter of appointment said 1 year. You knew that the request for proposal said 1 year.
Chair, I would think that, Chair, as I explained my understanding and what we see in practice would have covered part of that, in that we have never seen a company with this size, this complexity, put out an audit tender for only 1 year. If anything, Chair, I would think that we should have been able, which we did, Chair. We took comfort in the fact that the office of the AG gave concurrence, and I know that as part of the concurrence process, they do ask about inquire of the procurement process that has followed. Our appointment was also confirmed at the AGM, and at the AGM, Chair, all those who are charged with governance are there and able to raise objections or issues as appropriate. But Chair, the fact that our appointment was also approved, or the concurrence did come from the office of the AG. I do think we were able to take comfort on that, Chair.
Let me ask this question. If PwC's genuine understanding was that when this letter of appointment said you are appointed for 1 year, 1 financial year, it actually didn't mean that. It meant 5 years because of all the reasons that you have given. Why would PwC not have said to SAA, why do you write 1 year? Why don't you write 5 years, even if it's subject to renewals every year based on whether you have done the job properly the previous financial year? Why would PwC not say, why are you giving us a letter of appointment that says 1 year? Because maybe we all know this is for 5 years. Because if PwC has accepted a letter that says 1 year, 1 financial year, but its understanding is that this is for 5 years, SAA would be entitled, would they not be, after 1 year to say, we are requesting proposals for the following year, and you can't complain because you know that you are appointed for 1 year. So I just have this concern as to how do you accept an appointment on the basis of a letter that says 1 year, but you say your understanding as PwC is that this is for 5 years, but you don't point out to say, change this letter because you and I know that is for 5 years, or we only put in a bid on the understanding that is for 5 years. So your letter is, we are not prepared to do this job if you are restricting us to 1 year. We will pull out if you insist on 1 year. Why didn't PwC say that?
Chair, it would be a bit difficult for me to respond to, as I was not part of that initial process, Chair. I don't have a responsibility for that, Chair.
Sorry, your voice went down again.
Oh, sorry, Chair. Apologies. I was saying, Chair, I was not part of the process back then, Chair. So I'm not able to, I don't know how, I don't have a response for that, Chair. I cannot respond to that question, Chair.
Yes.
I might have to go back and just understand why that did not happen, Chair.
Yes. Would you accept it as an expected, a natural response that one would have expected from PwC to the letter of appointment if their understanding was this is for 5 years? Would you accept that what I'm suggesting would be the response that one would expect from PwC to say, well, you've got it wrong on your appointment letter because our understanding is that we are here for 5 years, and quite frankly, if you say 1 year, we think it's financially, commercially not viable, we will pull out.
I do understand where the chair is coming from.
Okay.
Ms. Mothibe, you made reference to the Auditor General's oversight. Are you aware that the Auditor General took the view during the term of your appointment that the appointment of auditors did have to follow a procurement process?
Yes, I'm aware that it does follow a procurement process.
And do you recall what the board of SAA's reaction to that was when they received that advice from the Auditor General?
I don't recall, Chair. I think you are talking about the. Can maybe just remind me which year you are talking about, Chair?
Of course, in 2015, the board of SAA wanted to move all the auditing services to Nkonki, and they received advice from the Auditor General that they could not do that without following a tender process. Do you know what the board's response to that advice from the Auditor General was?
Not off the top of my head, Chair.
We'll go to the minute later because it was one of the minutes that I assume you would have been looking at in your audit procedures. But just to jump ahead, the Board of SAA recorded that it was strange, quote, that the Auditor General required it to go out to tender for its audit services. Do you share that view of the SAA board, that it was strange that it should be required to procure these services in accordance with the PFMA?
I do not agree with the view of the board now.
Thank you.
I'm sorry. I don't know if it's me alone. I'm freezing.
I have never been so cold in my whole life, Chair, so it is not just you. It is terribly cold.
How far away from lunch? 30 minutes.
Chair, I don't have a difficulty, if it would be convenient, with us taking an early break now and we try and do something in the next hour and return at 1:30, if that would improve things, I don't know.
Well, I think maybe we should, if we can, just persevere for the next 30 minutes.
Yes.
And then during lunchtime, hopefully somebody can do something. I think some time back, they said they could do something to make the room warm. So hopefully after lunch, but I think it does take quite some time, but I think let's persevere if we can.
With fortitude, we'll do it, Chair, and we'll make inquiries over the break if there's something that can be done.
Yes, and yeah, I think if you have an overcoat or anything, feel free to use it.
You may see me return with the overcoat, indeed. Thank you. Ms. Mothibe, I want to move from the topic of your appointment to the association that PwC had with Kwinana and Associates. I suspect somebody might have been listening. Chair, it seems we might have been spared the freezing air that is circulating in the room, but let's see how it goes. Right, Ms. Mothibe, for this purpose, if we can go in your first statement, which is in DD 19A, and if you can pick it up at page 12, please.
I have the page, Chair.
Did you say 12? Or
12,
10?
yes, 12.
Okay.
Thank you, Chair. Now there on that page you have a heading, Payments Made by Nkonki. Oh, apologies. Oh, well, I think your heading is just slightly inaccurate. You say there, payments made by Nkonki to Kwinana and Associates. I've only picked that up now because what you deal with here is actually payments made by PwC to Kwinana and Associates. Is that right?
That is right.
Okay, so that's an error that neither you nor I picked up before. But what you're dealing with in this section of your statement, as I understand it, is well, let's give the background. The Commission picked up a series of payments to Kwinana and Associates, the auditing firm of Ms. Yake Kwinana, who was a non-executive member of the board of SAA and the chair of the Audit and Risk Committee. And we required of you in producing the statement that you address those payments. And can I take it that that's what you do from paragraph 46 on that page?
That is correct, Chair.
And then just to speed things up a bit, I just want to be sure that we're on the same page about the facts. As I understand it, there were 3 potential tenders that you bid together with Kwinana and Associates for. Is that right?
That is correct.
And as I have it, the first of those occurred in late 2014, early 2015, and you submitted a bid with her firm to the Eastern Cape Department of Education to provide internal audit services. Is that correct?
That is correct, Chair.
And that bid was unsuccessful, correct?
That is correct, Chair.
Then there was a second one. You describe it as being in late 2014, and that related to audit work done at PRASA. Is that correct?
Chair, that is correct, but Chair, just a correction, it was not audit work. Chair.
Right.
It was not audit work.
That I didn't have correct. So it was other work, professional services.
It was professional, just to inform the commission, it was work performed by one of our former companies that we have since disposed of, Combined Systems, and it was in the area of asset verification.
Right. Just give me a moment on that, if you don't mind. Sorry, so I'm just trying to understand. It was it was services that Kwinana and Associates rendered together with PricewaterhouseCoopers. Is that right?
That is correct.
Thank you. But not audit work.
Chair, it does not audit work.
Thank you. Thank you. And then the third bid was submitted in October of 2015 to provide consulting services to the Department of Military Veterans. Is that correct?
That is correct, Chair.
And that was also unsuccessful.
That is correct, Chair.
So just to summarize, 3 bids you put in jointly, 2 of them unsuccessful, 1 of them successful, correct?
That is correct, Chair.
And the total amount paid to Kwinana and Associates on the successful bid, can you tell us what that was?
The figure, Chair, is 6,187,799 rands and 90 cents.
Now, as I understand your statement, Mr. Mothibe, PwC has a whole internal policy that is in place in order to guard against these joint business relationships with people associated with their audit clients compromising their independence. Is that right?
That is correct.
And you take us through in your statement what those policies are. Is that right?
Yes, I do indicate it in my statement, Chair. That's correct.
And can you also confirm whether my understanding is correct, that PwC permits these joint business relationships when their materiality and significance is not of an order to compromise independence?
That is the correct statement, Chair.
And because of that policy and because of the impact for independence that these sorts of associations can have, as I understand your statement, PwC took steps to establish from Kwinana and Associates whether this work for that audit firm was material or significant. Is that right?
Yes, Chair. We have as part of our risk management, Chair, we have an office that looks after joint business relationships. And before we enter into such relationships, Chair, we confirm whether or not first of all, Chair, we do integrity checks on the persons involved. Once we are comfortable, Chair, we then also confirm that the amounts involved, whether or not they're material to either PwC or to that entity, because if they're material, Chair, they may have the effect of impairing one of the parties' independence, Chair.
And what threshold does that internal policy set for materiality?
Chair, in terms of the IESBA code, which is an international code, Chair, that we follow, and PwC code, Chair, the threshold that has been set is at 5% of total revenues. So the revenues from these contracts could never exceed 5% of PwC's own revenue. In terms of our policy, and we made similar inquiries of Ms. Kwinana in that regard, as to whether or not the said revenues would exceed those thresholds.
Yes. And as I understand your statement, PwC then did engage with Kwinana and Associates in order to establish whether the thresholds were met. Is that right?
That is correct, Chair.
And it did so at the end of 2014. Let's just go there. You'll find the particular email containing that query in DD19C at page 132.
I've got the Chair.
Thank you. These are copies of emails that you provided to the Commission. Is that correct?
That is correct, Chair.
And it was after we followed up, having read your statement. They weren't originally attached to the statement. Is that correct?
Chair, it was after we on the original statement, the Commission had not included inquiries as to the payments that were made to Ms. Kwinana. I think that came after our first interaction. So
Yes.
in response to that, we then provided.
Yes, so your statement referred to you checking, and then we called for the emails disclosing that checking. Is that correct?
That is correct, yes.
I want to start at the first email in time, which appears at page 132, as we had it. It's the bottom email in the second half of the page from a person named Nikki Wayne. Who is that?
Nikki Wayne was a manager in our marketing and business development department, Chair.
And if we pick up the last paragraph in that email, you'll see that Ms. Wayne says, please determine if the JBR, I understand that to stand for Joint Business Relationship, is that correct?
That is correct.
With PwC will be material for Kwinana if the fees for Kwinana for the current JRB relationship with PwC exceeds 10% of their annual turnover. The relationship will be deemed material for them. Do you see that?
I see that paragraph, Chair.
Why is this referring to 10% rather than the 5% required under the PwC policy?
The 10%, if my memory serves me right, was a threshold that was shared to us by Ms. Kwinana in terms of how she runs the business on her side.
So you apply a 5% risk, but she communicated to you she applies a 10% risk. Is that right?
Chair, from my reading of this, that is the case, Chair.
But just hang on. Were there interactions with Ms. Kwinana before this email went out?
Chair, the interactions with Ms. Kwinana would have been by the proposed engagement leader on the assignment, who then would have made inquiries to me as to whether or not I'm aware of first of all, there's a relationship between Ms. Kwinana and PwC, and whether or not there are any issues regarding independence.
Well, let's just unpack that a bit. Are you aware of, or did you yourself have, interactions with Ms. Kwinana before this email was sent, in which she disclosed to you 10% is her risk threshold?
Chair, the communication in terms of determining independence, anything in that space is run by a separate risk management department. I did not have any I didn't have communications with Ms. Kwinana in that regard. There's an independent, separate office that runs that process.
So how did you come to know the point you made a moment ago, that Ms. Kwinana's risk threshold was 10%?
Chair, in preparing for this, there were certainly inquiries with persons that were involved to understand where we were.
So somebody at PwC who was part of that team has told you before today that the reason why they asked for 10% was because that was Ms. Kwinana's threshold. Is that correct?
From the reading on the mess, yes, that is correct, Chair.
That is correct. Why does PwC apply Kwinana's threshold and not its own threshold?
Chair, the thresholds, there's different thresholds that apply that we apply. For Ms. Kwinana, she has got her own code. The PwC code goes further than what the international standards require, Chair. So we made inquiries. We got an understanding of what they apply and whether or not the proposed fees would have been breaching the threshold.
But why would PwC, who's concerned to ensure its own independence, accept the threshold of the partner? Why doesn't it apply its own threshold?
Chair, this work is carried out by the Risk Management Department. I'm not privy to the details of what goes on into that process. I have to take comfort on the work that is performed by the back office.
Is it permissible under the PwC policy to simply apply the threshold of the partner?
Chair, it is permissible. If it was not permissible, we would not have proceeded with the joint business relationship.
Can you direct me to where in the policy it says that's permissible?
Chair, I'll have to go and maybe during the break, Chair, we'll have to look at where we can deal with that, Chair.
Because let me tell you, I have not found it in the portions of the policy that you've provided to the Commission. What if the audit, the potential business partner's threshold was 50%? Would you apply it?
Chair, I would have to take guidance on that. We would have obviously the Risk Management Department has got guidelines that they follow, and based on the guidelines, they would then have made a recommendation, and would have followed that recommendation, Chair.
Are you aware of what Kwinana and Associates' response was to that inquiry made by Ms. Wayne in December of 2014?
Chair, if my memory serves me right, they confirmed that the revenues would be below the 10% threshold.
Well, let's go to it in particular. You'll find it in DD 19C at page 131. It's at the bottom of that page, the relevant email. It's from somebody named Lumka Goniwe. Do you know Ms. Goniwe?
No, I do not know Ms. Goniwe.
So you do not know that she's related to Ms. Kwinana?
No, I'm not aware of that.
And you'll see the subject there is Department of Education Internal Audit, Kwinana JBR query. Do you see that?
Yes.
So this related to that first tender that you bid together with Kwinana and Associates for, is that right?
Yes, that is right, yes.
And that was the one that was unsuccessful, correct?
This one was unsuccessful, yes, Chair.
Yes. And what Ms. Goniwe records there, I'll just read it into the record for convenience, is, "Good morning, Nishan. We've calculated our fees to be in the region of 4.1 million, excluding VAT. I confirm that Kwinana and Associates' turnover is more than 50 million. The BEE certificate reflects Kwinana and Associates before the demerger with Kwinana Equifin. I also confirm that Yake is a non-executive director of SAA. I hope you find this in order." Do you see that?
I see that, Chair.
And can we take it that PwC did find this in order because it proceeded to bid with Kwinana and Associates?
As I do indicate, Chair, the work would have been performed by the Risk Management Department that looks after joint business relationships, Chair. And one, we have to take comfort on the work that was performed by that area.
Do you always just take the say-so of the prospective joint business partner when you embark on these relationships?
I'm not too sure that I understand the question, Chair.
Thank you. Let me be clearer. I understand the process you followed simply to involve this email exchange. There was the request, tell us if it's over 10%. There was a response, it's not over 10% because our annual turnover is 50 million. Do you not probe any further than that? Do you just take what they say in the email as sufficient?
Chair, as I said, the process is run by a back office that looks after risk management. It's probably also important to add, Chair. Ms. Kwinana is a chartered accountant. She is a registered auditor. There is a code of ethics that guides how we deal with how we behave, Chair. And with her being a registered member of the bar, belonging to the same profession, I take it that she subscribes to the code and that there's no reason to doubt the integrity when the providers with numbers.
It was the independence of your audit, though, that was potentially to be compromised by this association. Did you make inquiries about this process at all at the time?
I did not make inquiries about the process. As I indicate, there is a back office that runs this process, Chair, and one takes comfort in the inquiries that they make.
And
I wasn't sure, Ms. Hofmeyer, whether the you in your question related to him or to PwC.
Oh, right. Well, I should be clear. It was PwC, but by this point in time, as I understand it, you were the audit partner. You'd taken over from your predecessor. We're now in late 2014. Is that right?
That is correct.
Thank you. So both, I guess then, Chair, you in the PwC broader sense, but you in particular, Mr. Mothibe. But you've indicated you did not make inquiries. Can I ask, and I take your point about the code of ethics, is it not customary just to ask the joint business partner for their previous year's financials so that you can just have an extra check on whether what they're telling you about the percentage of turnover is accurate?
Chair, I'm not part of that process, the GBR process, so I cannot comment on that question.
Do you think it would be a good step to take?
It does make sense, Chair.
What I want to put to you, Mr. Mothibe, and it's not facts that you would have had at the time, but if you were to learn that Kwinana and Associates' annual turnover for the relevant year, that's the year ending February 2015, was only 10,567,581 rand, would you then be concerned about entering into a joint business relationship with the firm who was going to earn 4.1 million rand out of that relationship?
Chair, I would be concerned.
It would constitute about 38% on my calculation of Kwinana and Associates' actual annual revenue for that year, turnover for that year. Again, you can do the maths over lunch if you want to check me. But Mr. Mothibe, let's move on. So you take what Ms. Lumka Goniwe is saying in response. She says 4.1 million is less than 10% because their annual turnover is 50 million, and you proceed. Is that correct?
Chair, PwC ran the process through its JBR office. We were provided with information that we had requested, and we had no reason to doubt the integrity of the information as it was provided to us.
I understand that, Mr. Mothibe. That was inquiries made in relation to the Department of Education bid, which we've confirmed in your evidence was unsuccessful. Then you bid with Kwinana and Associates on the PRASA bid, is that correct?
Chair, on the PRASA bid, as I indicated earlier, it was not PwC on the audit side. It was a subsidiary of ours that did the proposal. In that instance, Chair, Combined Systems, the company involved, did not follow due process. They did not make inquiries as required and put the joint business relationship through the necessary process. This information only came to my attention, in fact, when one started preparing for the commission.
Why didn't you say that in your statement then? That these processes were not followed in relation to the PRASA bid?
Maybe let's start with whether he accepts that he didn't say it.
Mr. Mothibe, do you accept that when you dealt with this from page 12 of your statement in DD 19C, you did not identify here that the processes had not been followed in relation to the PRASA bid.
That is the case.
That is
Chair.
the case.
Yes.
But today you concede that the processes were not followed for the PRASA bid. Is that correct?
That is correct, Chair.
So PwC, sorry, and I just want to get clear because I had to hesitate earlier. You drew this distinction between PwC and some other company, but then I clarified with you that this was PwC who entered into the joint business relationship with Kwinana and Associates for the PRASA bid. I thought you said yes.
I think, as the Chair, Combined Systems was a wholly owned subsidiary of PwC. Chair, they were required to follow due process. After we made a submission, we obviously, Chair, proceeded to get an understanding with all further details, and we have confirmed that they did not follow due process. They entered into the joint business arrangement, but they are wholly owned by PwC, and they were providing asset verification work at PRASA.
And PwC paid Kwinana and Associates invoices, didn't it, for this work?
The arrangement, Chair, as it works, is that even with our subsidiaries, PRASA required payment or the invoices to come from one entity only, even though we are a joint business relationship. So, because we own Combined Systems, the invoices would have come from PwC to PRASA, and immediately when we got remunerated for the work performed, we obviously, Chair, had to remit to Kwinana and Associates their proportionate share of the fees based on the amount of work they would have performed on the assignment.
So if we go to page 12, paragraph 50.3, you state there, in late 2014 and in the period up to 30 January 2015, PwC, with Kwinana as JBR partner, rendered professional services to the Passenger Rail Agency of South Africa. Do you see that?
That is correct, Chair.
Thank you. And that is a correct statement, is it?
As I indicated, Chair, it was Combined Systems who entered into the joint business relationship. Combined Systems being PwC at the time.
Who submitted the bid, PwC or Combined Systems?
Chair, I don't have access to the documentation, so it would be difficult for me to respond to that question, Chair.
Can I assist you? Because your evidence earlier was the PRASA wanted to be dealing with one entity, as I understood it. Is that correct?
That's correct.
That entity was PwC, correct?
My understanding was that when you said to submit the bid, I'm looking at the original, the actual documentation, Chair. Hence my response. I don't know what the document was on the documentation. Therefore, I cannot respond because I was not part of that process, Chair.
Does PwC take responsibility for its wholly owned subsidiary not complying with its requisite procedures?
That should be the case, Chair.
Thank you. And the consequence of that is that PwC entered into a joint business relationship with Kwinana and Associates for the PRASA bid in circumstances where it did not confirm whether that joint business relationship breached its own policy. Is that correct?
Yes, Combined Systems entered into the joint venture or the JBR without following due process.
And if Kwinana and Associates earned 6.1 million from that, and you were to learn that its annual turnover for the it would have been 2016 financial year was in the order of 21 million, do you accept my maths if I say that that was constituting more than a quarter of the annual turnover of Kwinana and Associates?
Your maths is correct. Yeah.
Thank you. And had PwC known that, it would not have entered into the relationship because it might have compromised its independence, correct?
That will be correct, subject to the work that we have been performed by the JBR office chair.
Thank you. Chair, it seems an appropriate time to end. We've hit 1 o'clock. Maybe warmth can be generated for the room in the break.
Yes, I hope so. I hear some noise back. I hope that it's for warming the place up and not taking us back to where we were before. So I'm sure somebody will take care of that. We are going to take the lunch adjournment and we'll resume at 2. We adjourn.